Hello, good evening and welcome to another episode of Law and Order on a Friday evening. Every week we take a topic on law and discuss it with an expert. And today we're going to do the same thing with an expert attorney. Today my guest again is Mr. Nishan Premathiratne, and he is an expert in both commercial litigation and other areas of commercial law, company law and arbitration. He has wide experience in that area, working on his own as well as very eminent senior attorneys in Sri Lanka. Nishan is also participated in he's involved in working with the World Bank in doing an index of the enforcement of contracts in Sri Lanka. He has, to his credit, he's also hailing from a background of where he studied on human genetics as well and some area of medicine, but then thereafter he came to practice in law. Nishan, welcome back to Law and Order. May I just divert a little bit and ask about your medicine and human genetics thing? Would you like to start on that in a minute?
Yes, thank you very much, Anakya, for a very colorful introduction of myself. Initially, my father was a doctor, my grandfather was a doctor, so there was a lot of parental pressure to take up medicine. So I was fortunate enough to get into medical college in the University of Nottingham, but after about a year of medicine I realized that it was not for me. So then I switched to a degree in human genetics, and then thereafter I was compelled to come back to Sri Lanka. So Sri Lanka, unfortunately, is not, human genetics is not the best field which to expand your horizons in. So thereafter I was day in and day out of court because I had my personal cases. So then I thought, why not take up law on my own so that I don't need to spend money on lawyers and I can appear on for my own cases.
Yes.
But still I have those cases, and I have lawyers who appear now for free, but still I love it, and I love the fact that I took on law.
Yeah, that's good. Now, commercial litigation, like I said in my introduction, is one of your forte area. If I ask a very broad question, probably, what is commercial litigation in Sri Lanka?
Commercial litigation would encompass intellectual property matters, yes, corporate company law disputes, arbitration matters. Then you get the admiralty matters in respect of ship arrests. Then you have also matters in respect of commercial transactions. So commercial transactions have been defined in the Act number 10 of 1996 with a quantum of 5 million. So 5 million or above, which has a commercial nature to it, can be deemed to be a commercial transaction. So in a nutshell, those 5 areas can be deemed to be part of the commercial litigation process.
Right. The commercial setting or the commercial courts, the commercial high courts in Sri Lanka, is it as exciting as it sounds, the way it is sounded, or does it do justice to the corporate litigant? I'm not trying to find fault with the court per se. What I'm trying to say is the setup, how it is done, how the work is done, and how the lawyers appear and how the process is done. Are you satisfied that the litigant gets justice?
Yes. Coming to the point of the litigant getting justice, well, our entire system, unfortunately, we have this issue of delays. So, notwithstanding the intention of creating the Commercial High Court and the commercial development of the Commercial High Court, I think, is in the proper track.
Right.
So we have an exclusive court with exclusive specialized judges to hear specialized matters. So in respect of matters such as company law disputes, intellectual property disputes, admiralty matters, or matters arising out of arbitrations, we have a specialized court. Now this court is not found everywhere in the island. It is only found within the Western Province. So the good thing about that is you get specialized lawyers going there and specialized litigants going to a specialized court in Colombo. So being a commercial court, the fact that it is in Colombo also ensures that the corporate world has access to it, and presently being the corporate hub being Colombo. So yes, we have issues of delays. We have probably the process can be speedier, and the time spent in litigation for a litigant should be reduced, but notwithstanding the intentions and the pros are, I would say, are higher than the cons of, or the delays in the creation of this court.
Right. Where do you think the problem lies? You know, we've been saying about these laws delays for the time I was studying law.
Yeah.
But where do you think is the problem lie? My question is it there is no political will from the government side to help out like in other areas of the government? Because we know certain areas of the country is far ahead than the litigation process. Or is it us, the lawyers, or is it something else?
Now, recently we had a national law conference, and I was fortunate enough to be the convener in that. Now, even in that, and as you correctly said, Chanakya, this has been a topic amongst lawyers from several years now, this laws delays. So what are we doing? We are every day talking about it, anything happening, right? Is it our fault, or is it the entire system which needs a revamp, right? I think it's a mixture of everything. So we need to look at jurisdictions to see how expeditious they are compared to us. Now, as a part of this National Law Conference, we are presently in the process of compiling a report to be submitted to the stakeholders, which include His Excellency the President and the Prime Minister, and they are quite eager for us to submit this, so that we would be presenting the issues which we believe needs to be addressed, and also the solutions. So that's all we can do as lawyers. So your question as to whether we lawyers can expedite this, I personally believe yes. We need not take up certain frivolous objections. I say frivolous because I feel it's frivolous. We take up objections and we move for dates, and those things we can curtail, because ultimately it's, I think there is a misnomer that having a lot of cases in your diary or allowing matters to drag is the best way forward, but I personally believe that is not the case, and litigants do not want to come and idle, especially commercial litigation, because the commercial litigant has two questions he generally poses. Number one, how long would it take, and how much would it cost? So unfortunately, we cannot answer the first question. So our second question also is unanswerable. So because of that, we need to appreciate that expeditious processes would actually increase the volume of work. So,
if I may go a little bit deep on this, lack of pre-trial discussions or proceedings, isn't that one of the reasons for delays, for these objections and all that to come at trial stage? And also, now in places like in Melbourne, I personally know you can take in certain areas, not necessarily commercial, civil areas, you can take a divorce without going to court. I think most countries can. We still can't. Are these sort of lack of procedural law, are also contributing to laws delays, which are beyond, of course, the hands of lawyers?
Yeah, no. We cannot come to, can we say that there are no pre-trial steps in the Civil Procedure Code? Now, the Civil Procedure Code is quite a comprehensive piece of work. Now you get the sections such as interrogatories, discoveries, which I personally believe we lawyers don't utilize them.
Utilize it. Yeah, that's the problem.
We can utilize them. Now, even if you look at the section 94 for interrogatories, you can ask certain questions in respect of your trial, and it's only 10 days which is given for the other side to answer. So it's a very short time frame. But if you go in, you go into the process of interrogatories, unfortunately, that process will take another 6 months due to certain reasons, certain factors, whilst I think the intention of the legislature was to finish that expeditiously. So, yes, but whether now agreeing on your documents prior to the trial date, those sort of things, you get now in international arbitrations, your documents are filed, tendered, and the parties interchange it before the trial. So you know what you're getting, and if you're objecting to this, you will object to this way before the hearing start. So rather than waiting till the trial stage and you object on a document, and this entire thing drags on for a long period. So pre-trial steps, I think, can be formally introduced, and it's in the pipeline. We are too suggesting that in our report, that pre-trial steps should be brought in, or at least sought to be tried in the commercial court as a pilot project. We can see how it works. And thereafter, with possible success, which we believe it would be a success.
Then what about the things like not being able to take a divorce out of court completely? You have to go in that date. What about the lack of procedures in that? Don't you think it's time that we introduce those procedures?
The thing is, the substantive law in respect of divorce is on a fault basis still.
Right.
So even if it is a settlement, one party will have to accept matrimonial fault. Now, for that purpose, that substantive law is, unfortunately or fortunately, it's in this presently like that. So you need a leading of evidence, a limited leading of evidence, even in a settlement divorce. So you need the plaintiff or the plaintiff to get on box and give evidence for a little period of time. So that process has to be done in terms of our substantive law. So then court will decide, enter decree in favor of the plaintiff, even in a settlement. So I believe other jurisdictions have settlement on consent. You can divorce on consent, but that is not yet in our jurisdiction.
Okay. Now you were very much involved in this World Bank report doing the index. Now, as I see, why in this particular business doing index, Sri Lanka is ranked very poorly, even though we have special commercial courts and all that, very poorly in doing business. Why do you think this was like this?
When we did this report, I was fortunate enough to work with the Senior President's Counsel, Dr. Harsh Kabral. We submitted a comprehensive report to the World Bank as to why we believe these are the issues which we are facing at the present moment of time. Now, yes, Sri Lanka is ranked 161 in the index to enforce a contract. So we take 1,300 odd days to enforce a contract. Now, that is quite, I reluctantly use the word appalling, because we are, even with our South Asian neighbors, we are behind them. So there is only 189 countries in this index. So Sri Lanka, with a specialized court, you ask me, why are we still behind this? But unfortunately, the thing is, the contracts, all contracts are not commercial transactions. All contracts are not even held and resolved in the jurisdiction of the Commercial High Court. So you get disputes arising which cannot be brought within the framework of the Commercial High Court. So you might have a contractual dispute in Anuradhapura. You might have to file it in the District Court of Anuradhapura. So cohesively, it's an analysis of the entire process that we have come to a number of 1,300 days. So we take 1,300 days. So whether the commercial, yes, probably by introducing these pre-trial steps, we should be able to at least bring this down a little bit further.
Right. Now, we are aspiring to be the hub of litigation, dispute resolution mechanism process, like have an international arbitration center. I think the background work or the legislative work for that is being done. Am I correct?
Yes.
Right. Given this drive to do, and Sri Lanka is moving very hard, very fast to become the we are thinking of the megapolis state here, from island to continent, that thing and all those things. This sort of issues that out of 189 countries, we are the 161 position in 1,300 days to execute a contract. Do you think we can attract to be the hub of dispute resolution?
It's a serious problem, because a foreign investor would want to know the ease in which he can take his repatriating funds. The ease of doing that is a primary concern.
Right.
So in order to analyze that, what would he look at? The index. Right. So he sees Sri Lanka at 161. And we take 1,300 days to, if he enters into a contract to enforce that, that takes 1,300 odd days. So that is a serious problem.
What in your report, did you also, when you